Today, we are doing a deep dive into a really fascinating and, often overlooked corner of the law, Rule 91 of the Rules of Court, all about Escheats.
Welcome to LexAI. We're your AI-powered partner in mastering the law, and we're here to combine artificial intelligence, legal analysis, and jurisprudential insight to make complex doctrines, just like this one, totally clear, visual, and easy to understand.
Okay, let's jump right in. So what exactly is escheat? Well, at its core, it's the legal process where property goes back to the state. Now, this only happens under two very specific conditions. First, a person dies without leaving a will, that's what we call dying intestate, and second, they have absolutely no legal heirs. The whole idea behind this, the legal rationale, is a fundamental principle. Property can't just be ownerless. It can't be res nullius, so the state steps in to claim it.
So here's our game plan for this explainer. We're going to walk through the entire process laid out in Rule 91, section by section. We'll start with how a petition gets filed, then move to the super important notice and hearing phase, the judgment itself, then a surprising little window for recovery, and we'll even touch on a special case for illegally acquired property before we wrap it all up with a neat summary.
All right, so where does this whole legal journey begin? Well, Section 1 lays out the very precise conditions for who can file the petition and when.
The first thing you absolutely have to know is who can kick this off. And it's not just anybody. The power to file belongs exclusively to the Solicitor General, acting on behalf of the Republic. The where is also very specific. It's got to be filed in the regional trial court where the deceased last lived. Or, if they didn't live in the Philippines, then it's where their property is located. And this is a huge point. It's an action in rem. That means the case is filed against the property itself, not against any particular person.
This brings us to a classic tricky question, the kind you'd see on the bar exam. So, picture this. A distant relative knows for a fact that there are no closer heirs. Can they just go ahead and file the escheat petition themselves to kind of get the ball rolling?
And the answer is a hard no. The law and the cases on this are crystal clear. Only the state, represented by the Solicitor General, has the authority to initiate an escheat proceeding. This is to make sure the process isn't misused by people who might be a little too opportunistic. A private citizen can, of course, report the situation to the government, but they have zero power to file that petition themselves.
Okay, so once that petition is filed and the court gives it the green light, what's next? Well, the court has a really critical job. It has to make sure the entire world knows about this case. And that's where Section 2 comes in.
This is where you really see due process in action. The court's order setting a hearing date has to be published. Not just once, but once a week for 6 consecutive weeks in a newspaper of general circulation. And let me tell you, this is not just some procedural formality. It is a strict, mandatory requirement. It's how you notify any potential claimants, wherever they might be in the world.
So what do you think happens if this rule isn't followed to the letter? Let's say the notice was only published for 4 weeks instead of 6. Down the road, some actual heirs show up and they argue, hey, we were never properly notified. Is the court's judgment still valid?
Absolutely not. That judgment would be completely void. You see, that 6-week publication requirement is what we call jurisdictional. That means without it, the court has no power, no authority to even hear the case. If you cut that period short, any judgment the court makes is a total nullity. It's as if it never even happened.
So, assuming all the notice requirements were perfectly met, the process can finally move on to the hearing and the judgment under Section 3. This is where the court makes its final decision. Now, before a court can issue that final judgment, it has to go through a 4-point checklist. First, it has to confirm that the publication was done correctly. Second, it needs solid proof that the deceased died without a will. Third, it has to be established that there really are no known legal heirs. And finally, the court confirms that no one with a legitimate claim has come forward to oppose the petition.
So once the property is officially escheated, where does it all go? The law is very, very specific about this. It has to serve a public purpose. Any personal property goes to the municipality where the person last lived. Real estate goes to the municipality where it's actually located, and in both of these cases, the property or its proceeds are specifically for the benefit of local public schools and charities. It's a really cool mechanism to turn otherwise abandoned wealth into a community benefit.
But what if an heir really does exist, and they just had no idea any of this was happening? Is it just game over? Well, the law provides one final window of opportunity, a kind of safety net, in Section 4.
And that window is exactly 5 years.
An heir, a divisor, or anyone with a legitimate claim has 5 years from the date the judgment was handed down to come forward and try to recover the property.
Let's just visualize this timeline to see how strict it is. Say a judgment is issued on June 1st, 2025. The absolute, final, last day for anyone to file a claim is June 1st, 2030. The very next day, June 2nd, that claim is forever barred. There are no extensions, no excuses. It's a hard deadline.
So let's test this principle again. An heir shows up and files their claim 5 years and 2 months late. Their reason? They say they live abroad and were totally unaware of the newspaper publication. Do they have a shot? Will their claim prosper?
Once again, the answer is a big, definitive no. The Supreme Court couldn't be clearer on this. That 5-year period is absolute and it is jurisdictional. Remember how we said the case is in rem? That means the newspaper publication legally counts as notice to the entire world. So, unfortunately, pleading that you personally didn't see it is not a valid excuse after that 5-year clock has run out.
Now, Rule 91 isn't just about people who die without heirs. It has another really important use under Section 5, which covers something called reversion suits.
Let's just compare the two so it's clear. Regular escheat, everything we've talked about so far, is triggered because there are no heirs. But reversion under Section 5 is triggered by a violation of the law. The most common example is the constitutional ban on foreigners owning land. Another key difference is the venue. A reversion suit is filed where the land itself is located, not where the owner last lived.
Okay, let's pull all of this together now and do a quick rundown of the key principles and checkpoints of Rule 91.
Here's the whole process in a nutshell. Section 1, it all starts with a petition from the Solicitor General. Section 2, that 6-week publication is a non-negotiable jurisdictional requirement. Section 3, the judgment sends the property to the local government for the public's benefit. Section 4, heirs get one last shot, a 5-year window to make a claim. And Section 5, the rule also covers reversion, which is how the state takes back property that was acquired illegally.
So, what's the big takeaway from Rule 91? It's really a powerful lesson in sovereignty. It teaches us that property must always have an owner, and if there's no private one, that owner becomes the state. To master this whole process, just remember this simple acronym, PNJCR: Petition, Notice, Judgment, Claim, and Reversion.